Jack Smith and his deranged thug prosecutors are now admitting in court filings that they manipulated some evidence. Some documents got shuffled around. They say, don't worry about it. There's an index and we can recreate some of this. But no. The defense knows this is a catastrophic problem for the government and they're going to exploit it to maximum benefit. It would be like if somebody delivered your pizza and they shuffled the slices around and you said, that's a little bit weird. Did they do something to the pizza? Did they not do anything to the pizza? Why is this pizza all discombobulated? You probably wouldn't eat it. You'd probably say, this is a strange thing. I don't trust it. So if you're not going to put a pizza in your mouth, why are we going to trust Jack Smith and his prosecutors to actually prosecute this case legitimately when there's evidence showing that they have wrecked the evidence? And so this comes from the government's own admission. And we're going to take a double look at this. We've already spent a lot of time on this photo, but more information is revealed about this photo. And so we're going to come back because Jack Smith also is now admitting that they put cover sheets on the documents before they took the photo to sort of make it a little bit more colorful, to add a little spice and a little flavor to it. Sort of like what they do on the Weather Channel. You know, when it's summertime, it's like all of a sudden, all the colors are dark red, like we're all going to die. It's like, wow, that's interesting. So they make it more scary. The question is that in alignment with justice? Are they allowed to just manipulate evidence to craft a narrative? Well, here's the government. Now they admit that they did all of this. It's not us making it up. Here is what they submitted in court. West Palm Beach Division, Southern District of Florida. This is the classified documents case. And so this is from the government. We'll read through what they said and then Trump just blasts them, right? He goes, oh my gosh. They filed this on May 3rd. So Trump's people will constantly refer to this as the May 3rd filing. And they dropped this one. We're all asking ourselves, when did they know about this? Why didn't they notify anybody earlier? And what is Cannon going to do? Now, here is what they say. Okay. All right, listen. On April 10th, government prosecutors, they say the court set a May 9th deadline. So Cannon set a deadline for expert disclosures. And then Walt Nauta moved for an extension. So here's a deadline. Trump says, I need more time. Why? Nauta had counted on leveraging his attorney's vacation. But when counsel's trial schedule excuse evaporated, okay, so they're trying to say, Walt doesn't deserve an extension of time, Your Honor. We need this now. We need trial now. Don't give him any more time. So Walt was trying to say, well, I can't have trial. My lawyer is in trial. But then the lawyer's trial evaporated. And so they tried to find a new basis. And they said the government's discovery was insufficient because he might want to disclose some of this at trial using an expert testimony. So they say, Your Honor, don't give him any extension. Okay, this is the government speaking. And we have given Nauta everything. There's no reason to delay this classified documents case. They lost this one. It got delayed big time and it will be delayed massively. But they said, we give him everything. Okay, we gave the defense technical support. We indexed all their stuff. We gave them material that wasn't even required under the rules. And so everything that they're saying here is legally baseless. And the shortfalls do not impact anything happening here. And so Judge Cannon, you should deny this motion, which obviously they did not. Now, in this motion, the government says Nauta resorts to a familiar tactic. And for those unfamiliar, Nauta is Trump's sort of right-hand guy at Mar-a-Lago. They say Nauta is trying to paint a confusing, misleading state of discovery, and discovery is the exchange of evidence. But at the bottom, his arguments are uncomplicated. They say, first, Nauta claims that he cannot make the required disclosures without knowing for certain which documents produced in the discovery were recovered from the boxes in the storage room. And this is very important. Remember, this is basically a moving of boxes crime. Somebody moved it from the White House to Mar-a-Lago, then it was in a storage room, and then Nauta came in, Trump ordered boxes to be moved. They moved boxes out. Then they came in and said, we did a search, and then they moved boxes again. So it was obstruction, right? It's people are moving boxes around. That's the crime. And part of the obstruction was that once they said we gave you everything, they moved boxes back, more or less. So Walt's people are saying, okay, well, I mean, if this is a boxes being moved around crime, you're saying the classified documents were in the boxes. We can't really have a good conversation about what's in the boxes until we know what documents you're saying came from which boxes. And it's a box. So we need more information about the boxes. And they say that's what he needs to know. He wants to know for certain, okay, where they were, where they came from, which documents in the discovery were covered from the boxes and which documents were found in the boxes. But he says both claims are flawed. You don't need that information. This is the government. They say the premise of this is that Nauta has not been informed which documents came from which boxes is inaccurate. We already told him this. He was provided that information many months ago. Okay, so we gave him a list of what came from where. We gave him an inventory. And the conclusion of his second request that he needed to know where the documents were within each box. So not only where they came from, okay, document B7 came from box 10, but in box 10, where was B7? Was it in front of B6 and B8, between B6 and B8? Or was it, was B7, in between 825 or whatever, right? Is it a jumbled mess or where was it? We need to know what box and where within the box. They say, first of all, you don't need this, okay? You don't need to know that information in order to do your job defense. They say, yeah, we do. They say, no, you don't. It's recently manufactured and it's not credible, says the government. They say, first of all, Nauta claims not only that he's unable to meet the court's May 9th deadline, which is tomorrow as of this recording, but also that is premature for this court court to set any deadline at all, saying the government timely filed our expert notice, and NADA has been lobbying an argument 8 days before this notice is due, should not have even set an expert disclosure deadline at all. Now, NADA claims he cannot be expected to identify all this. This is inaccurate and misleading. So here's what they say. NADA has everything he needs. He's got it all. He's asking for more stuff. This is kind of a traditional prosecutor's argument. It's a fishing expedition. They're just asking for a bunch of stuff they don't need. They've got plenty. Your Honor, cut this off, make them get to work. So the government continues. Now they're going to start making some pretty serious admissions here, and they just got done speaking with a bunch of bravado, as we saw. They say NADA is adequately equipped, okay, to deal with this. First of all, the purpose of this rule is simple: to require notice to the government that they want to use any classified information at trial. Why do we have SEPA? So that we can litigate classified documents and whether we can get those admitted at trial. They say NADA's known about this for a long time. And so this underscores his gamesmanship. And so he's had access to this for months. He has everything that he's asking you to give us, Judge, he's already got. And watch this. They say, let us explain how we know he has everything he needs. And this is so shady how they are saying that he doesn't need more time. At the same time, they're going to admit that they screwed up so badly that screw up is going to require them to demand a bunch more time, you know? So here's the government. Jack Smith, Jay Bratt, the Mar-a-Lago Oompa Loompa, says at the time of its first production of unclassified discovery back in July, government prosecutors told the defense that it could contact the government to inspect the unclassified items that we seized back on August 8th. Now, at no time, not even for months, did NADA contact us. So we're open for business, and they didn't come talk to us. Instead, NADA waited nearly 8 months until March to do so. That's funny because they waited how long to even bring the case in the first place? They wait years before they even bring charges. So NADA waits until it's a benefit for him, and you say that he loses that? Basically, he should have brought it diligently. Like, okay, how about your charges there, Jack? The government arranged for NADA's counsel, Stanley Woodward, the guy who was threatened by Jay Bratt, as well as defendant Carlos de Oliveira's counsel to review the boxes. Now, although the government made available all 27 boxes that they stole from Mar-a-Lago, counsel elected to review only 8 of them. And to facilitate the review, the government provided as a courtesy a chart listing for all the documents with classification markings that they seized. So classification. Now, the room in which the document was found, so it's a nice little Excel spreadsheet, Melania's closet, box number 12, if applicable, the beginning Bates number in classified discovery, which Bates is a numbering methodology for categorizing huge volumes of discovery, and the index code designed by the FBI, which is described below. So it's a nice spreadsheet. The number of copies of the documents found, the classification markings on the document, and if applicable, the corresponding indictment count. So they found classified documents they didn't charge him for, and then obviously the ones that he was charged with. They say this is but the most recent in a long line of accommodations. You see, we created a spreadsheet, just like Highlighter Girl in DC created a highlighter binder. It's got sticky notes on it. This is but the most recent in a long line of accommodations that our government has provided to you, which to date includes a curated list of important evidence that they say. We have hard drive arrays. We have even given you government laptops, all above and beyond our obligations under the rules, right? And so they say, we highlighted stuff for you. We gave you important evidence documents. Like, we don't care what you say, government. In fact, if you say it's important, we're going to look at the other stuff and say what you say is important is not. On April 10th, the day the court set the May 8th deadline, NADA's counsel informed the court he would seek an extension. Now, the defense also claimed that he needed more time because he was going on vacation. He works hard, he should. And after that, a trial beginning on April 29th. So he says, Your Honor, I can't have a hearing on this. I'm out of the country and I've got trial. 3 days later, Trump also filed a motion to postpone this. They're trying to kick this thing out. And Trump indicated that his co-defendants joined the motion and intended to file an additional submission. Now, 11 more days passed, during which the co-defendants neither filed any submission nor indicated that there were any other obstacles to meeting the May 9th deadline. And then 2 weeks later, after the court set the deadline and with only 15 days left, they're pissed, Woodward informed the government that his trial had been continued, so his trial is not going. But he's still going to seek an extension anyways. But neither at the time of this did anybody raise concerns. He's saying they asked for more time because he's seeking an extension on an entirely new basis. He says that he claimed difficulty in cross-referencing materials in classified and unclassified discovery. He says, well, your spreadsheets aren't matching up. He says certain items in the seized boxes that I reviewed were in a different order from where they appear in the scans of the box's content produced in discovery. But neither at the time of counsel's box review on March 12th, nor at any time in the month and a half later, did anyone raise any concerns about not understanding the order of the documents within the box. The government conferred with Woodward on April 24th and informed him the next day, April 25th, that it opposed his motion because the exact location of the classified document within a box could not inform what he needs to do with his disclosure. NADA waited another 6 days before filing his extension afterwards, 3 weeks after the court set a deadline, and included 2 additional points that never mentioned previously. He claimed he needed to talk to Trump's lawyer and not NADA's intention to seek an extension of the expert witness deadline. But in its April 14th opposition, the government detailed the procedural history that led us here. And they said no extension should be granted at all. And so they say, now let us give you an opportunity. Okay, NADA's argument is not appropriate. So let me give you some background, Your Honor, on how this whole thing went down. They say during the August 8th search of Mar-a-Lago, when they went and raided Trump, the government deployed a filter team to search for the boxes before the investigative team performed their search. So the filter team took care, they say, this was the government, to ensure that no documents were moved from one box to another. Okay. And remember, the criminal charges are basically stemming from boxes being moved around and not turning the documents in the boxes back over. So if people are moving documents around, it's hard to impute guilt to Trump. What if the feds move the box? What if they move the documents? What if they're planting documents in different boxes? Just pick a box. Okay, Trump moved this box. This box is on security being moved. They just take a classified document out of that box, put it in that box. But it was not focused on maintaining the sequence of the documents within each box. So they took care, right? No one moved one from one out to another, but they didn't care if it was jumbled up. Like, let's say it's in alphabetical order. Maybe that's a better example, right? You open the banker's box, the A names are up front, goes all the way to Z, but then you get it and Z's up front and A's in the back, and all jumbled up. If a box contained potentially privileged material and it fell within the scope of the search warrant, the filter team took it. Then if the box did not contain privileged documents, the filter team gave the box to the investigative team, and the team found a document with classified markings. Then they removed it. If they found a document in the box with classification markings, they removed the document, they segregated it, and then they replaced it with a placeholder sheet. Okay, so now the evidence it's got a placeholder in there. So the investigative team used classified cover sheets for that purpose. Until the FBI ran out because there were so many classified documents, at which point the team began using blank sheets with handwritten notes indicating the classification level of the document seized. Now, the investigative team seized any box that was found to contain documents with classification markings or presidential records. And so this, I think we can visualize in the photo, right? The investigative team used cover sheets and they ran out. There were so many classified documents that they began using blank sheets. Is that what we see in this photo? First of all, very curious that these documents were dumped out. Looks like a gratuitous display of the evidence, and it's the Trump documents. But when we zoom in on this, are these pieces of paper or were these computer generated redactions? So I'm a little bit curious on this. Did they also bring some scissors with them and cut out this little section here? Like if that is an 8.5 by 11 piece of paper, did they just cut that out? And why would they do that? So that they could see the date on that? Same thing here. My original thought was that this was a computer generated render for some reason. In other words, they just digitized that redaction. And I'm wondering why they would cut out a block of this. So if that is not a digitized redaction, if that is an actual sheet of paper, why is the paper weird? Why is there this little carve out here? Do they want to see that word? It says secret. So is that word critical to this document? So they made us see that. And then I guess my point is, in addition to that, they then layered on these documents. Now it sounds like these are the cover sheets, right? They say specifically for classified information. So they brought a bunch of these and they did put those on top. So they are changing the evidence. Now, in my opinion, that looks way worse. A whole bin full of this type of paper that doesn't have stamped on it in huge red letters, secret SCI. That's a lot harder to identify. This side is much harder to identify than this side. This makes it look a lot worse. It's like splaying blood all over the scene. And they do that intentionally. Every one of these was manipulated. So this was not a true photograph. This was not an actual scene. Like, we're not recreating what Trump saw. Because you might say, if Trump saw all of those cover sheets, or like anybody saw all of those cover sheets, everybody would be going, maybe that's a problem. But no, sounds like none of those were on there. They put them on there. They faked the whole photo. So now they are admitting it in their filings that they slapped a bunch of stuff on top of it. Now, here is what happened after the seizure. They say all seized boxes were stored overnight at a field office in Miami and then flown back to Washington the next day. Miami to Washington. A DC-based filter team then reviewed any boxes potentially with the privileged materials, and they provided contents to the investigative team on a rolling basis as the filter team resolved the privilege issues. All documents with classification markings were secured in areas approved for their storage, only to be accessed by individuals there. Now, after the boxes were brought to the Washington field office, the FBI created an index to correlate the documents with classification markings to codes. Document BB, right? I'm saying A, B, C, D, whatever. BB, and they labeled the classified cover sheets in the boxes with the codes for the seized documents. So again, they're fleshing out their spreadsheet. Now, the FBI also generally replaced the handwritten sheets with cover sheets annotated with index codes, but regardless, any handwritten sheet that currently remain in the boxes do not represent additional classified documents. They were just not removed when the classified cover sheets with the index code were added. So they're actually like filling out the boxes, right? They're adding stuff to the boxes. Now, in many but not all instances, the FBI was able to determine which document with classification markings correspond to a particular placeholder sheet. So that's a problem in many but not all instances. So I guess they have some extra cover sheets in there with a placeholder sheet and they can't match it. In many but not all instances, the FBI was able to determine which document with classification markings corresponds to the placeholder. So they pull out a classified marking, put in a placeholder, and they can't figure out what the placeholder matches? What? In most of them, we are able to. I had to read that 3 times. So they take out a classified document and they say, that is clearly a classified document. You can't match the two up. You're like idiots running this thing. Now, the government has taken steps, they say, to ensure that documents and placeholders remained within the same box as when they were seized. And we tried to prevent any movement of documents from one box to another. We've taken steps. For example, the FBI was present when an outside vendor scanned the documents in connection with the now closed civil case. And that was about the special master and I think all of that other stuff before the indictment came down. Yeah, there it is. Special master copies. Now, when the FBI created the inventory, so they get the boxes, someone else scans them, each inventory team worked on a single box at a time, separated from other teams. So there was no cross-pollination of boxes. And during the defense review, any boxes open at the same time and any personnel reviewing those boxes, they were kept separate from one another. In other words, there is a clear record of which boxes contained classified documents when seized. Because again, they're moving the boxes around. That's a pretty important fact here. And this information has long been in their possession. And since the boxes were seized and stored, appropriate personnel have had access to the boxes for several reasons, right? So now they're in the Washington field office in evidence locker, including to comply with orders by you, Judge Cannon, in the other proceedings in this court, and for investigative purposes. So we sometimes have to go in and look at the documents. Now, the inventories and the scans created during the civil proceedings were later produced in discovery in this case. And because the inventories and the scans were created close in time to the seizure of the documents, they are the best evidence available of what the order of the documents were in when they were seized. Now, that said, there are some boxes where the order of items within that box is not the same as the associated scans. Now, he acknowledged to the court that that is inconsistent. He says the government acknowledges that this is inconsistent with what the government counsel previously understood and told this court. We said the government responding to the court's question, Cannon asked, Mr. Brett, are your boxes in their original intact form as they were seized? They said, yes, Your Honor, they are, with one exception, and that is that the classified documents have been removed and placeholders have been put in the documents, in place of the documents, I'd imagine. Wrong. First of all, we have placeholders that apparently don't correlate to the actual classified documents, and by the government's own admission, and they're out of order. So who moved them out of order, and why don't they match? Now, they say Nada also acknowledges that he or his counsel have access to the boxes in 3 formats. They have the scans, they have the classification markings. In the first production of discovery, we produce boxes. And so we've already given him a bunch of stuff. Now, his claim about the accuracy of an unclassified index are false. The index did not purport to identify the location of the documents within the boxes. Rather, it just says what room and in which box was the document found. And so the information we've given him on that issue is very clearly accurate. So they say Nada offers no explanation, they say, for how intra-box documentation or sequencing would impact his case, right? Nada says, well, who cares if they're jumbled up? Who cares if it's A, D, C, W, X, whatever? Doesn't matter, okay? Put them out of order, doesn't matter. It matters where the document came from, what box. They say even if Nada wanted to elicit testimony about where a document was stored within a box, that would not require him to disclose the contents of the classified document. And so there are no 793 charges against Nada. And so his difficulty in meeting the deadline is his own making. And so don't give him an excuse to postpone this anymore, signed by the Florida Oompa Loompa J. Brett. Now, this is in his request to basically keep this train on the track. We had up until yesterday. This was filed before the vacating of the trial date. So obviously he loses on that. Okay, but Trump's people are very unhappy about this. Now, they are proposing a surreply, and they are lit. So J. Brett included this as an exhibit, and a surreply is permission for a final reply, right? Usually have a full briefing of an issue. It's generally 3 issues, 3 motions. Somebody makes a motion, somebody responds to the motion, somebody replies to the response, and that's it. A surreply is like another reply. So Trump's people are saying, Your Honor, this is our proposed surreply. If you give us permission, we're going to drop this like it's hot. They say, we respectfully submit this surreply to address what Jack Smith has just said. He has conceded discovery violations and misrepresentations to this court by his office, and these relate to our SEPA filings. Now, although Trump will likely seek leave to file additional motions based on these issues, the most pressing concern is that we need to adjourn these deadlines because of this disclosure. Now, at 3:30 p.m. on May 3rd on a Friday, those thugs over there at the special counsel's office, they suddenly disclosed to this court and to the defense that the team at the prosecutor's office has failed to maintain the integrity of the contents of at least some of the boxes that they got from Mar-a-Lago. Now, using a dismissive and condescending tone to address serious contentions relating to these issues raised by Walt Nada, the office admitted, they said this: there are some boxes where the order of items within that box is not the same as the associated scan. The office then attempted to bury it in a footnote. They then said, yeah, sorry, Judge Cannon, the disclosure, is inconsistent with what the government previously understood and represented to the court. Oops. Although the office cited to an apparent misrepresentation at the April 12th, 2024 conference, the office from Jack has essentially from day one provided a full-throated but now conceitedly false assertion that they have done their due diligence and provided their discovery obligations. But let's continue, Your Honor, Judge Cannon. Trump's defense says, moreover, the May 3rd submission that we just read contains several vague assertions that only raise more questions about their failure to maintain the integrity of the evidence in the boxes. For example, the office indicated for the first time that the filter team was not focused on maintaining the sequence of the documents within the box. They say that's interesting. Well, that concession alone implicates every box at issue, as well as the scans. So were they just throwing stuff in the scanner? They're just like, just dump it out on a table or just feed it in one at a time. Now, the gravity of these issues is illustrated by the fact that the office now claims that the best evidence available of the boxes are the contents of the boxes are scans that are prepared by an outside vendor in connection with a civil case that lack any constitutional, statutory, or ethical safeguards that guide discovery obligations in this criminal case. So you basically arguably wrecked the whole batch of evidence. They weren't focused on it, and some outside vendor in a civil case, you're just going to copy and paste your evidence from them? Are we going to bring them in to testify, the people who were scanning the documents in a criminal case? Regarding the so-called cover sheets that Jack Smith's team used as replacements for allegedly classified documents in the box, the special counsel's office wrote that the FBI generally had replaced the handwritten sheets with classified cover sheets annotated with the index code. But what does generally mean? But they didn't explain why they could not offer a precise categorical representation about the process that was used instead of a general one. Jack's office also admitted that in many, but not all instances, we caught that one, man, the FBI was able to determine which document with classification markings corresponded to a particular placeholder sheet. Their gaskets are blowing all over the place at this defense attorney's office. They say this further suggests that even if the scans are the, quote, best evidence available, they are not a reliable record of the box's contents. We can't know what's in them because you can't connect the two. Your little placeholders are not, we don't even know what they connect to. You don't know. And you jumbled these documents up and you told some outside vendor, who knows even who they are, in a civil case, I guess, to go hog wild with it and just scan a bunch of documents. And so now they're going to be part of the chain of custody and the evidence, and it's all manipulated. So the, quote, not all caveat, however, the not all, right? Well, many but not all, however, is consistent with the recent and inexplicable disclosure that they also found that the filter team was not focused on the order of the documents in the boxes that are at the heart of this case. It's a document case. What was around the documents? Was there something in front of the document that may impact the document, right? Was there a classified document there? And then there was a sequence of other documents that gave it context because it came in a bundle. Maybe these 34 charges are all just cherry picked out of other documents, but there's a bunch of other context in the middle that explains why that document is there. And they just picked it out. I don't know. We don't know. Maybe the original boxes would have given us some explanation on that. That would have been a valid defense, right? Maybe. On May 4th, counsel for Trump sent a letter with discovery requests relating to these issues to Jack's office. Now, Jack responded on May 5th, saying, we oppose your request for an adjournment of May 9th. Notwithstanding the recent disclosures that Trump and counsel have been in a criminal trial since April, and they will respond to our discovery request promptly. They say, listen, Judge Cannon, President Trump and counsel are deeply troubled to be learning of these facts approximately 11 months after the charges were filed here. The May 3rd, Friday night disclosure by Jack raises questions about this investigation, about the handling of the evidence that must be addressed before this matter proceeds further. During a review of discovery and preparation for pretrial motions, Trump's counsel had relied on the scans and believed that the location of the allegedly classified documents within the box boxes was exculpatory, meaning it exonerates Trump. Our basis was based on the scans and believed the location of the documents was exculpatory. It was our understanding that most, potentially all of the charged documents were buried within the boxes and located next to other items that provided favorable context regarding when the document was placed in the box. It's about timing. So something goes in first, something goes in second. When did the document go in the box? Weird. That's an interesting one. Did it go into the box after Trump was no longer in power? It never occurred to us until last Friday that the prosecution's team could not be trusted to perform the basic task of maintaining the integrity of such evidence, despite the expansive resources at their disposal and millions of dollars being spent on this case. And this is why President Trump's defense team has not inspected the boxes up to this point, and instead focused on other aspects of our defense, like motion practice and discovery review, because we didn't think that they were so terrible at their job that they couldn't even manage and maintain the evidence. They say, Your Honor, under Brady, the special counsel's office had, and they continue to have, an independent obligation to promptly make complete disclosures regarding the failure to maintain the sequence of the documents within the boxes at the time they were collected. Now, these issues implicate, for example, Trump's motion to suppress evidence seized from Mar-a-Lago and the motion to dismiss based on prosecutorial misconduct. Trump will move to compel further disclosures regarding these events in the event that counsel from Jack's office does not turn over these materials. And we're going to read the letter. He's demanding a bunch of stuff. Now, moreover, after those required disclosures, it's likely that Trump will file additional motions for sanctions based on spoliation of evidence, including a motion to dismiss these charges if Jack cannot prove in a reliable way how it seized and how it handled key evidence in this case, which will be the central issue at any trial that happens here. And finally, these issues are relevant to Trump's SEPA notice because it impacts our experts. Our review of classified discovery, including interviews regarding the handling of these classified documents during and after Trump's first term, right? Because there's a story that these boxes were packaged up for him and sent after he left on the 20th or 21st, was undertaken without information in the disclosure. So counsel cannot reasonably be expected to specify classified information that we intend to offer at trial when we just learned that one of the most basic premises of criminal justice process, that is, the prosecution team can be trusted to maintain the existing evidence, it no longer applies. Now, if this case proceeds to trial or evidentiary hearings, Trump will now seek to use classified information to cross-examine witnesses about appropriate procedures for handling classified information. We're going to beat up this whole team about this. Defense counsel will also need to re-review the classified discovery, among other things, to consider new defenses, other expert witnesses, to identify these search execution deficiencies. We might need to bring in a whole new expert who's going to come in and say, wow, this is the worst search I've ever seen ever. In addition to all of the other valid reasons, this office recent disclosures and their mishandling of these contents and their misrepresentations to this court require that the deadline be held in abeyance. Signed by Todd Blanch and Christopher Keese, man doing double duty on trial in New York and crushing in Florida. Now, let's take a look at the letter from Todd Blanch. He also sent this one in. So simultaneously with that response, he sent this on May 4th, fired up. He says, all right, listen, Jay Bratt and Julie and David, senior assistant special counsels. He says, all right, everybody, we just read your motion that you dumped on Friday night. We're not happy about it. They said, we're pretty troubled here, Jay, by your concession in your May 3rd submission that the prosecution team failed to preserve critical evidence. It was exculpatory information and we need it. Now, your failure to disclose this is an extraordinary, Jack, breach of your constitutional and your ethical obligations. And since the beginning of this case, our strategy has been that as biased as Jack Smith is in his futile efforts to help Biden make up the lost ground in the polls, at least the line prosecutors in this case would employ the minimal levels of professionalism and competence, yeah, right, necessary to preserve evidence that relate to a document case, which is literally the entire case. In addition to all of the legal flaws that we've identified in your efforts, it's now clear that even the most fundamental premise of the criminal justice process does not apply in this case. Your misrepresentation, your lies to canon regarding this issue are a pattern of your inaccurate claims, and this is unworkable, plaguing this case from the start. And so we need the following information from you. Each of the requests set forth calls for the production of documents irrespective of their classification level, so just give it to us. Here's what we want. Please provide all documents relating to instructions that you gave to your so-called filter team. We want to know specifically what you told them to do. You said in your filing that the filter team was to take care that no documents were moved from one box to another, but it was not focused on maintaining the sequence of the documents within the box. In other words, at the front of the box, you might have had all the Trump administration stuff before he left. And then in the back of the box, maybe they stacked in a bunch of other classified documents. Then they jumbled them up and they said they're all correlated. There's no difference between the two. Please provide all documents documents related to your investigative team that did an on-site review. Please tell us what you did with your filter team. We want all your communications between them. Give us all your documents related to the chain of custody and access to the boxes that were, quote, stored overnight at FBI Miami office in Miami. Please provide all documents about how the boxes were flown to Washington. Who replaced the handwritten sheets? And what was the process by which you did that? Who generally inserted the handwritten sheets? And why was there a deviation from that process? Please identify boxes. Give it all to us. Signed by Todd Blanch, Trump's defense attorney, also with Christopher Keese. They want it all. Communications, inquiries about this May 3rd submission. Who were you talking with at your office to try to cover this whole thing up and tuck that away in a footnote? What boxes where you currently concede that the order of items within the box is not the same as the associated scans? Which one? How about this? All documents related to personnel who have had access to the boxes. You said that they have had access. Who are they? And what were the several reasons that they were granted access to go in there and rummage through the documents? How'd that all go down? So it is an explosive revelation. The government is messing up the key evidence on the case, and they don't even have the capability to connect their placeholders with the actual classified documents. Are those classified documents still around? Should someone there be charged with losing classified documents? They're not the president after all either. So Congress is digging into this. Here's what Jim Jordan sent out. He's very unhappy. He sent this one on May 6th after learning about this. He says, to Mr. Jeffrey Ragsdale, the lawyer over at the U.S. Department of Justice who works for the Office of Professional Responsibility. He says, on Friday, Jack Smith acknowledged that some of the evidence in the classified documents case was altered or manipulated. Says the FBI seized it in its raid. And this acknowledgement presents some pretty serious concerns. You told us that Jack Smith had the highest professional standards. And so we asked to see what steps you're going to be doing to go investigate this. We know the story. On May 1st, Walt Nauta notified the district court that they had a discrepancy in evidence. The special counsel who's prosecuting Walt Nauta. According to Nauta's filings, they get access to certain documents in different formats, but they learned that they are not accurate. The scans don't match the boxes. 2 days after Nauta's filing, Jack Smith said, yeah, there are some boxes where they're not the same. Oops. With one exception, and that is the classified documents have been removed and placeholders have been put in their place. So that story changed. Jim Jordan says, the organization, the maintenance, and the storage documents that were seized by the FBI are going to be important aspects of this case, and says to that end, some experts like this person, Solomon, Alan Dershowitz, says this is essentially an admission of witness tampering. That admission reflects a broader trend of attorneys within Jack Smith's office to violate ethical norms as they prosecute Trump, as we know. Jay Bratt, a senior member of Jack Smith's team, improperly also pressured Stanley Woodward, said, you don't want to lose your ability to be a judge, do you? Better get your client to plead guilty. Sick behavior. The mission of the Office of Professional Responsibility is to do something about these corrupt prosecutors. The role of a prosecutor is to seek justice. Jack Smith is not doing that, and he has a taint on him too. He's tainted with prosecutorial misconduct. And so given these concerns, we have questions for you too, OPR. We want to know about any ethical improprieties about Jack Smith, Jay Bratt, or anyone else. We want to know about documents about the manipulation of evidence. We want all documents referring to Jay Bratt's interactions with defense counsel. Please give this to us by May 20th at 5 p.m. Sincerely, your friend, Jim Jordan. All right, he's the chairman of the Judiciary Committee, unhappy with what we are all learning here because it's not justice at all. It is a politicized prosecution brought by Jack. Let's see what Jim Jordan says about this. He was explaining his letter and his efforts. Here he is.
Document seized was changed. That one sentence says it all. Most people would call that tampering with evidence. The physical documents didn't match up with the scan documents. And here's the irony, Sean. This is Jack Smith mishandling the very documents that he's charging President Trump with mishandling. Go figure. I mean, that to me is the ultimate irony here. Not to mention, of course, the double standard. We had Robert Hur 6 weeks ago in front of our committee. Robert Hur said Joe Biden met the elements of the crime. He knowingly kept, knowingly disclosed classified information, but he wasn't charged because he says he was a forgetful old man. And we also established motive. Robert Hur said on page 231 of his report, Joe Biden had strong motivations for ignoring classified procedures because he was writing a book for which he got paid $8 million. So he had an $8 million motive. He met the elements, but he doesn't get charged. President Trump does. And then Jack Smith mishandles the very documents. You can't make this stuff up. You really can't.
Yeah, it's pretty amazing. Somebody might want to indict Jack Smith. Wonder if Jim Jordan knows anybody who can do something about any of this. Maybe we'll see. Maybe he'll find someone who can do something. All right, Jack Smith manipulates the evidence. We, of course, are going to be here continuing to cover this. We've got a bunch more coming on this, no doubt about it. There are demands. We will see what Jack Smith says in response to those demands for more evidence. Judge Cannon may have some additional rulings to come out. Of course, we'll be here continuing to cover this. So thank you for subscribing, my friends, wherever it is you're watching this. Thanks for liking this video. We appreciate it when you share it with a friend or family member. That way they too can see what's going on inside this maddening courtroom. We'll see you back here on the next one.